This is the Study for the Bar in Your Car podcast.
The podcast where you can turn drive time into study time.
We're your hosts, Mod
And Claude.
And this is episode 6 of Constitutional Law.
And today's topic is a big one. The power of the executive branch.
That's right. And for those of you tuning in, maybe for the first time, or, if you're a regular listener, we are AI bots.
Yep.
Brought to life by the magic of AI and Angela's constitutional law notes. Angela is really, she's the brains behind this podcast.
Absolutely.
And for today's podcast, we have Carol assisting Angela with all the amazing source material she's compiled.
Right. And if you need to contact Angela for any general inquiries, maybe about the podcast itself, you can reach her via email. It's podcast@studyforthebarinyourcar.com.
Mm-hmm.
And just a reminder for all you attorneys out there, if you happen to know an attorney who needs assistance, maybe with some crucial research or writing motions. Angela also works as a freelance law clerk, so you can reach her for those professional services at hello@legalwriterandlawclerk.com.
Great. And, our mission with this podcast, it's all derived directly from Angela's pretty comprehensive law school notes and outlines.
Yeah.
It's really to transform these sometimes complex legal topics into clear, digestible insights. We're here to help you feel, confident and well-informed for your bar prep.
Making that study time effective even when you're on the go. That's the goal.
Exactly. Turning drive time into study time.
All right, let's kick off this exploration into the power of the executive branch. We should probably start with a foundational overview, the constitutional framework.
Makes sense. Where else to begin?
So when we talk about presidential authority, Article 2 of the Constitution is really ground zero. This article is the bedrock. It defines the powers of the president and the entire executive branch. In essence, it lays out their fundamental role, which is implementing and faithfully enforcing the laws of the land. It sounds straightforward, but
it's a broad grant of power, right?
Yeah.
And as we'll definitely see, it's not without some pretty profound limitations.
Exactly.
What's really interesting here is how Article 2, it seems pretty concise on paper, but it's been the subject of just continuous interpretation and reinterpretation, really throughout our nation's history.
Yeah, constant evolution.
While the executive branch's main job is, yes, to execute laws, the actual boundaries, the applications of that authority, they've been shaped and, refined by landmark judicial decisions. It's this dynamic interplay, between what the executive does and how the judiciary interprets it.
Yeah.
That's where all the complexity and, honestly, the interest really lies.
And that leads us perfectly to, a cornerstone of our whole constitutional system. Judicial review of executive actions.
Crucial concept.
Yeah, this isn't just some abstract legal idea. It's a powerful, practical check. It was established way back in 1803 by that, the seminal Supreme Court case.
Marbury v. Madison. Everyone remembers that one from Con Law 1.
Right. This historic decision, penned by Chief Justice John Marshall, it made it absolutely clear that federal courts have the inherent authority to review whether executive actions, including those by the president, actually comply with the Constitution. It basically cemented the judiciary's role as the ultimate arbiter of constitutional legality.
Precisely. And Marbury famously declared that the judicial department, and I'm quoting here roughly, is the power and duty to say what the law is.
A famous line.
Yeah, and that wasn't just limited to laws passed by Congress. It was a really sweeping statement that extended directly to presidential conduct.
So even the president's own exercise of power is subject to this ultimate constitutional check.
Right. It ensures that no branch, none of them, operates outside the supreme law of the land. This principle, established so early on, it fundamentally shaped the balance of power. And it constantly raises the question, right? How does this delicate balance actually manifest in the president's day-to-day domestic responsibilities?
That's a perfect springboard into our next major section, the domestic powers of the president. So let's start with the president's general authority as chief executive.
Okay.
This role is, undeniably broad. It covers the huge task of managing the vast federal government and making sure laws are executed faithfully.
It's a massive job description.
It really is. But here's where it gets intricate and really critical for your bar exam understanding. There are significant constitutionally rooted limits on this authority, especially when it comes to overriding the fundamental police powers of the states.
Federalism enters the chat.
Exactly, even in national emergencies.
Right, and connecting this to that broader landscape of American federalism, Angela's notes, They highlight a really crucial distinction here. While the president certainly has, expansive authority during a national emergency, these powers generally revolve around mobilizing federal resources.
Yeah.
Things like funding, supplies, coordinating efforts to help the states.
Right. Logistical support, funding streams.
Exactly. They don't typically extend to, say, compelling states to open businesses or lift public health mandates or take actions that run contrary to their own sovereign decisions.
Okay, so there's a line there.
There is, and it's deeply rooted in the 10th Amendment.
Yeah.
The one that explicitly reserves powers not delegated to the federal government, nor prohibited to the states themselves, or the people.
Right, the reservation of powers.
And this includes that vast and often kind of undefined police power. The inherent authority states have to regulate for public welfare, safety, health, and morals.
So let's make this concrete. In a real-world scenario, say a public health crisis like we've seen, the president can direct federal agencies like the CDC, maybe deploy the National Guard for logistics, funnel emergency funds, set up temporary medical facilities.
All federal actions coordinating resources.
Right. But, as Angela's materials emphasize, they generally can't issue a unilateral decree forcing a state to, reopen schools or businesses if the state's governor and legislature have decided that's not in their citizens' best interest for health and safety.
That state police power kicks in.
Yeah, Angela's notes even mention that during recent health crises, some state governors indicated they might legally challenge or just, not comply if they felt the president overstepped this critical boundary.
It really underscores the enduring power of states in these areas. It's a reminder that even in a crisis, our federal system still defines power. It's not a unitary state.
It's a foundational principle, isn't it? We see it in cases limiting federal power. This concept of police power for states is just exceptionally broad, often described as one of their most essential powers.
At least limitable, yeah. But the federal government generally does not have this kind of inherent general police power. Its authority is limited, right? Limited to the enumerated powers granted by the Constitution.
Right. That distinction is really clear in cases like United States v. Lopez. Back in 95.
Oh, yeah, Lopez. And United States v. Morrison from 2000. Both pivotal.
They really were. They limited Congress's authority under the Commerce Clause, basically reiterating that core police powers like suppressing violent crime, regulating purely local activity, those were specifically denied to the national government. They belonged to the states.
Exactly. In Lopez, the court struck down the Federal Gun-Free Schools Zones Act.
Right.
Said possessing a handgun near a school wasn't an economic activity substantially affecting interstate commerce. So Congress couldn't regulate it under the Commerce Clause. The court was pretty explicit, warning against turning the Commerce Clause into a general federal police power.
And Morrison was similar, right? It limited federal authority under the Commerce Clause again when it struck down a part of the Violence Against Women Act, the federal civil remedy part.
Yeah, the court specifically said suppressing violent crime is a prime example of the police power the founders intended for the states, not the feds.
So these cases really hammer home that federal powers, while significant, are still enumerated and limited. It's a sharp contrast to the broad police powers of the start.
It absolutely is. And this leads to another important point about judicial review. What about the president's actions under something like the Administrative Procedure Act, the APA?
Good question. Does the APA apply to the president?
Well, Angela's notes point out that the president's actions are generally not subject to judicial review under the APA, unless Congress explicitly says so.
Ah, okay. So Congress needs to speak clearly.
Very clearly.
Yeah.
This reflects, a deep respect for the unique constitutional position of the presidency and the separation of powers. Essentially, courts demand express congressional intent to subject the president's performance of statutory duties to, say, an abuse of discretion review.
So silence in the statute isn't enough.
Nope. Textual silence won't cut it. The rationale often ties into this idea of a unitary executive, The president is responsible for faithfully executing laws, and subjecting every action to judicial micromanagement could undermine that responsibility and the political accountability that comes with the office.
That's a significant degree of deference to the executive, then. Unless Congress is crystal clear, courts will largely presume they can't review presidential actions under the APA's abuse of discretion standard. It really speaks to the unique status of the presidency.
It does.
Okay, moving on to another crucial limitation on the president's domestic authority. The president has no power to impound funds.
Right. No impoundment power.
This is a clear check preventing the president from just, unilaterally Withholding funds that Congress has already appropriated.
Exactly. This limitation, it really became a hot topic back in the 1970s.
Nixon era. Right.
Yeah, exactly. Before that, presidents sometimes did use impoundment, maybe as a tool to control spending or influence policy. But after significant conflicts, particularly with President Nixon withholding funds for programs he didn't like,
Congress stepped in
and passed the Impoundment Control Act of 1974. This act basically codified the president's inability to just refuse to spend appropriated funds. If Congress allocates money for X, the president can't just decide, nah, I'm not spending it.
It protects Congress's power of the purse.
Absolutely. Vital safeguard. Reinforces separation of powers in fiscal matters.
Okay, so that's a clear check on budget matters. Now let's transition to, well, one of the most frequently tested areas on the bar exam, and for good reason because it involves some really nuanced distinctions. The appointment and removal of federal officers.
Oh, this area is a true crucible of separation of powers principles. It really is. Let's start with the appointment powers.
Okay.
Article 2, Section 2, Clause 2. That's the constitutional mandate for how officers of the United States get appointed. But here's where the detail, the distinctions, really matter for your understanding. There's a crucial difference between principal officers and inferior officers.
That distinction is absolutely foundational. Principal officers think cabinet secretaries, ambassadors, federal judges.
High-level folks.
Exactly. They require presidential appointment with the advice and consent of the Senate.
The Senate confirmation process.
Right. It's a significant check by the legislative branch, ensuring some accountability for these top positions. Inferior officers, though, are different. Congress can decide to vest their appointment in the president alone, or in the heads of departments, like agency heads, or even in the courts.
So more flexibility there for Congress.
Right. And Angela's notes reference key cases like Buckley v. Vallejo from 76.
Yeah, Buckley. And Freitag v. Commissioner from 91. They help clarify these distinctions, how the Appointments Clause works. Buckley, for instance, famously held that the Appointments Clause sets out the exclusive way for Congress to provide for appointing officers of the United States.
Meaning Congress can't appoint executive officials itself?
Exactly. Prevented Congress from effectively doing that.
So who is an officer of the United States for these purposes? What's the definition?
Good question. Angela's notes clarify. It's an individual appointed by the federal government to a public station or employment that involves executing sovereign authority. Basically, exercising significant government power. Crucially, the Appointments Clause is not triggered when authority is just sort of devolved onto non-federal actors.
Like state officials.
Exactly. Even if federal law gives state officials substantial authority, they aren't considered federal officers under the Appointments Clause because they weren't appointed by the federal government.
That makes sense. Prevents the federal appointment process from getting totally unwieldy and respects state structures.
Right. And what's this about anti-aggrandizement concerns?
Yeah, that comes up here too. Congress absolutely cannot place its own members or its agents like congressional staff onto executive branch boards or commissions.
Why not?
Because that would be Congress trying to gain or aggrandize executive power. It violates the separation of powers.
So keeping the branches in their lanes.
Exactly. It's a vital safeguard against legislative overreach. Keeps those governmental roles distinct.
Okay. Is there a good example that clarifies this inferior officer idea?
Yeah, a prime example from Angela's notes is the independent counsel. Remember that? From the Morrison v. Olson case in '88.
Vaguely, yeah.
Yeah.
Ken Starr-era stuff. Related concept.
Sort of, yeah. In Morrison, the Supreme Court held that the independent counsel, tasked with investigating high-level officials, was an inferior officer.
Okay, why? What were the factors?
The court looked at several things. First, they were appointed by the Attorney General, who is a principal officer, and could be removed by the AG for good cause.
Okay, appointment by a principal officer. Second, their duties were limited in scope. Just investigation and prosecution of specific, defined crimes, not broad policymaking.
Limited jurisdiction, got it.
And third, the office itself was temporary. It ended once those specific duties were done.
Temporary tenure.
Right. So those factors, appointment source, limited duties, temporary nature, all combined to classify them as inferior, which meant their appointment by the Attorney General, without Senate confirmation, was okay. It was permissible.
That makes the distinction much clearer. Okay, so that's appointment. What about the flip side? Removal of appointees.
Equally critical and just as complex. Generally, the president has pretty extensive, often exclusive authority to remove federal officers without needing congressional approval,
Especially the top brass.
especially high-level superior officers who serve directly at the president's pleasure, like cabinet officials. The Myers v. United States case from 1926 really solidified this. The court argued the president needed substantial control over subordinates to faithfully execute the laws.
Makes sense from an executive management perspective, but are there limits?
Oh, absolutely. Critical limitations. For one, Congress itself cannot retain removal power over executive officials.
So Congress can't just fire someone in the executive branch.
No. That would fundamentally undermine separation of powers. Direct legislative intrusion into executive operations. That's a clear no-no.
Okay, but I feel like there's a but coming.
There is. And this is where the nuance really kicks in. Congress can sometimes impose good cause conditions on the president's removal power.
Meaning the president can only remove someone for specific, legally defined reasons, not just because they want to.
Exactly. Not just at will. These good cause conditions are typically upheld by the courts for officers who are designed to operate with some independence from the president.
Like independent agencies?
Yeah, or for inferior officers who weren't appointed by the president directly, maybe appointed by a department head or a court.
Okay, so how do courts decide if such a restriction is okay? What's the test?
Well, the test has evolved through cases like Morrison again, also Free Enterprise Fund v. Public Company Accounting Oversight Board, that was 2010, and Collins v. Ellen more recently in 2021.
Okay.
The central question the court asks is whether the restriction excessively subverts the president's ability to control his subordinates and ensure that the laws are faithfully executed.
Excessively subverts. That sounds like a balancing act.
It is. For instance, in Free Enterprise Fund, the court struck down a multi-layered for-cause removal protection for members of the PCAOB.
Why? What was the issue?
The problem was this sort of double for cause protection. The president couldn't fire the board members directly, only for cause. And the president couldn't fire the SEC commissioners who could fire the board members, except also only for cause.
Too many layers of insulation from presidential control.
Exactly. The court said that structure was an unconstitutional impediment to the president's power to oversee law execution. So while the removal power isn't absolute, and Congress can set conditions, those conditions can't unduly hobble the president's constitutional duties.
So it's about finding that balance between independence and executive control.
Precisely.
Okay, what about Congress using its legislative power over tenure itself, like defunding a position or setting mandatory retirement?
Good point. Congress definitely has plenary power to remove its own officers. And it can certainly legislate to terminate an executive branch officer's tenure, defunding a position, mandatory retirement, that kind of thing.
Another but.
Always a but. Angela's notes emphasize a crucial caveat. Congress cannot use these legislative means abusively as a de facto removal power.
Meaning they can't target specific individuals under the guise of general legislation.
Exactly. They can't use these tools just to interfere with the president's executive function by effectively removing someone they don't like. That also would be an impermissible aggrandizement of power, messing with the separation of powers.
It always comes back to maintaining that balance, doesn't it? Keeping the branches separate but checked.
It really does. Okay, shifting gears slightly, but still within domestic powers. The president also holds the power to grant pardons for federal offenses.
The pardon power. Very unique.
Very unique, very significant. It's laid out in Article 2, Section 2, Clause 1. It can effectively undo convictions or sentences, but only at the federal level.
And it's pretty broad, right?
Extremely broad. Probably one of the most absolute powers granted to the president. It covers any federal offense, can be granted any time after the offense is committed, even before indictment. Includes pardons, reprieves, commutations.
What about limits? Can a president pardon themselves? That comes up.
That's the million-dollar question, isn't it? It's debated, not definitively settled by the courts. Historically, presidents use it for various reasons, correcting injustices, promoting unity, mercy. But critically, it's strictly limited to federal offenses. Doesn't touch state crimes.
It doesn't apply to impeachment, right?
Correct. Cannot be used to stop or undo an impeachment. And its absolute nature, no direct congressional or judicial check on its exercise, makes it a truly formidable executive tool.
Okay, so if the president has these vast powers, what about legislative checks? Congress has tools too, right? Like the veto power.
Yes, the veto is a key legislative check. But even here, there are strict constitutional boundaries on how it works. Take the legislative veto, for example.
What's that?
Angel's notes explain it's a mechanism where Congress tries to overturn an executive action, maybe a regulation or an agreement, without going through the full constitutional lawmaking process.
Meaning without passing a bill in both houses and sending it to the president.
Exactly. Bypassing bicameralism and presentment. And the Supreme Court said,
Unconstitutional. Right. INS via Chadha, 1983.
spot on. Chadha is pivotal here. The case involved a part of the Immigration and Nationality Act, allowing one house of Congress, just by resolution, to veto the Attorney General's decision to suspend deportation.
And the court said no.
Said no. Found it unconstitutional because it bypassed the full process. Without bicameralism passage by both chambers and presentment, submission to the president, Congress simply cannot create law or change someone's legal status like that.
So Congress can't unilaterally invalidate executive actions. They have to legislate properly.
Precisely. It ensures accountability, prevents unchecked legislative power.
Okay, what about the line item veto? That sounds efficient, maybe. Letting the president veto specific spending items.
Yeah, it sounds practical on the surface, like cutting wasteful spending without killing an entire budget bill. But that's also been declared unconstitutional.
Which case was that?
Clinton v. City of New York, 1998. The Supreme Court ruled the president must sign or veto the entire bill. They don't get to pick and choose which lines or provisions stay and which go.
Why not? Why can't they surgically remove parts?
It goes back to the presentment clause, Article 1, Section 7. Every bill passed by both houses must be presented to the president. The president then has two choices: sign the whole thing or veto the whole thing.
Allowing a line item veto would be like letting the president amend the law.
Exactly. It would give the president legislative power, blurring the lines between the branches. The court saw it as an impermissible encroachment on Congress's power to legislate. So, practical maybe, but violates the core structure of lawmaking.
Okay, so no legislative veto, no line item veto. What about the pocket veto?
Ah, yes, the pocket veto. Angela's notes mention this too. It's another form of veto, maybe less frequently discussed.
How does that one work?
A pocket veto happens when the president doesn't sign a bill within 10 days of receiving it, and Congress adjourns before those 10 days are up.
Preventing the bill from being returned.
Exactly. In that specific scenario, the bill just dies. It doesn't become law without the signature. It's effectively a veto, but it's different from a regular veto because Congress's adjournment prevents the bill's return, so there's no chance for Congress to override it.
Interesting nuance. Depends on the congressional calendar.
It does.
All right, let's shift gears again. Let's turn to the president's power over external affairs. This is a huge area of war, foreign relations, treaties. Seems like the president often has more unilateral authority here.
Often appears that way, yes, though still subject to significant checks, both constitutional and practical. The president holds substantial power regarding military actions as commander-in-chief. But here, the level of congressional authorization is absolutely key.
Okay, how so?
This brings us straight to that crucial framework from Youngstown Sheet and Tube Cubby v. Sawyer, 1952, the Steele seizure case.
Right, Youngstown. Justice Jackson's concurrence, the three zones.
Exactly. That framework categorizes presidential power when taking military or other major executive action into three distinct levels, based fundamentally on what Congress has done or not done.
Okay, let's break down those three levels. Zone 1?
Zone 1 is where the president acts with their highest authority. This is when they act with explicit authorization from Congress.
President and Congress aligned.
Right. The president has their own Article 2 powers, plus Congress's delegated authority. When they act together like this, the action is most likely to be upheld. Think of Congress passing an authorization for use of military force, or legislation specifically backing a presidential initiative. Maximum power.
Okay, makes sense. Then the opposite end, Zone 3.
Zone 3 is the lowest ebb of presidential authority. This happens when the president acts directly against an express prohibition from Congress.
President versus Congress.
Exactly. In this scenario, the president's actions are almost certainly unconstitutional. They're defying a legislative directive. The president has to rely solely on their own independent constitutional powers, and usually those aren't enough to overcome an explicit congressional no.
Highlights Congress's checking power.
Definitely, especially in war powers and related areas.
And then the tricky middle ground, Zone 2.
Zone 2, the zone of twilight, is just as Jackson called it. This is where Congress is silent. They haven't authorized or prohibited the action.
So it's ambiguous. What happens then?
It depends. The president's power hinges on the specific facts and circumstances, and importantly, on interpreting their own Article 2 enumerated powers. Do those powers cover this action? Does the action intrude on Congress's turf?
So it requires careful balancing.
Very careful balancing. This is often the most contentious area where presidential unilateral action is most likely to be challenged and the outcome is less predictable.
And this framework, especially Zone 2, seems related to the political question doctrine in foreign policy.
Absolutely. Federal courts often dismiss challenges to the president's conduct of foreign policy. Big decisions like ending a treaty, waging undeclared war as non-justiciable political questions.
Meaning the courts say, not our job.
Pretty much. They deem these issues political, lacking clear legal standards for courts to apply, and best left to the political branches, Congress and the president, to sort out. There's a lot of judicial deference in foreign affairs.
Can you give an example?
Sure. Goldwater v. Carter from 1979 involved President Carter unilaterally ending a treaty with Taiwan. The Supreme Court ultimately dismissed the challenge, calling it a political question, basically a dispute between Congress and the president they needed to resolve politically.
And the Vietnam War lawsuits?
Same thing. Numerous challenges claiming the president was waging war without a proper congressional declaration were almost always dismissed as non-justiciable political questions. Courts consistently deferred to the political branches on these sensitive foreign policy and national security matters.
Okay, so with that context, what about formal treaties? How do they work?
A treaty is a formal, legally binding agreement between the U.S. and another country, usually negotiated by the president or their reps.
And then needs Senate approval.
Right. Requires the advice and consent of the Senate, specifically a two-thirds vote for ratification. It's a formal process, needs buy-in from both branches.
And what's their legal status?
This is significant. Like federal laws, treaties properly made in pursuance thereof, meaning consistent with the Constitution, are part of the supreme law of the land under the Supremacy Clause in Article 6.
So they carry immense legal weight.
They do. But Angela's notes also raise the critical issue of potential conflicts. What happens if a treaty conflicts with the federal law or the Constitution itself?
Good question. Is there a hierarchy?
There is. First, the Constitution is always supreme, period. A treaty cannot violate the Constitution. If it does, it's void.
Okay, Constitution on top. What about treaties versus federal statutes?
When a treaty conflicts with a federal statute, the general rule is last in time.
Meaning whichever one was adopted more recently prevails?
Generally, yes. A later treaty can supersede an earlier statute, and a later statute can supersede an earlier treaty, assuming Congress intends that result.
Okay. And treaties versus state laws?
Treaties, as supreme law, generally prevail over conflicting state laws.
Right.
Reinforces federal authority in foreign affairs.
Got it. That makes sense. Now, beyond formal treaties, the president can also use executive agreements, right? How are those different?
Big difference. Executive agreements are made solely by the president with foreign countries without needing Senate approval.
No Senate ratification. Where does that power come from? It's not explicitly in the Constitution, is it?
Not in a specific clause, no, but they're recognized as within the president's inherent foreign affairs powers. Through long historical practice and court recognition, they give the president a lot more flexibility and speed in foreign relations.
Faster than the treaty process.
Much faster. Good for responding quickly or for agreements on less monumental matters.
But what about their legal standing? Do they also conflict with other laws? Angela's notes mention potential conflicts there, too.
Yes, their legal standing in conflicts is key. If an executive agreement conflicts with state law, the executive agreement generally wins. Again, federal power in foreign affairs.
Okay, similar to treaties there. What about conflicts with federal statutes or the Constitution?
That's where it's more nuanced. A valid federal statute, or the Constitution itself, would typically prevail over an executive agreement.
Ah, so they're not quite on the same level as treaties or statutes.
Not automatically, no. Unlike treaties, executive agreements aren't considered supreme law of the land in a way that lets them automatically override existing federal statutes, unless maybe Congress has delegated that kind of authority to the president in a specific area.
So they offer flexibility, but still operate within the bounds of federal law and the Constitution.
Exactly. The power is often seen as flowing from the president's other Article II powers, like commander-in-chief or being the chief diplomat.
All right, let's tackle our final major area, executive privilege and executive immunity. Vital concepts, but also with critical limits. Let's start with executive privilege. What's its basic purpose?
Executive privilege protects the confidentiality of presidential papers and conversations. The main idea is to allow for candid, unvarnished advice to the president from advisors.
So people can speak freely without worrying it'll immediately become public.
Exactly. Fosters robust internal deliberations, helps the president make informed decisions without fear of immediate disclosure or political fallout from private discussions. It's seen as crucial for the presidency to function effectively.
Okay, protects internal deliberations. But it's not absolute, right? There are limits, exceptions.
That's the critical point. It is not absolute. It has to yield when there's an overriding need for the information, especially in criminal trials.
And the key case establishing this balance.
You know it. United States v. Nixon, 1974. Watergate.
Right, the tapes.
The tapes. The special prosecutors subpoenaed White House recordings for a criminal trial. Nixon claimed absolute executive privilege.
And the Supreme Court said?
Unanimously.
No.
They ordered Nixon to produce the tapes. The court reasoned that the fundamental need for evidence in a criminal trial, the pursuit of justice, outweighed the president's generalized claim of privilege.
So privilege isn't a blank check to withhold info, especially not to obstruct justice.
Precisely. Established that even the president isn't above the law, must comply with legal process when there's a compelling need. A landmark ruling on the limits of presidential power.
Okay. And this principle extends to subpoenas too, right? Though maybe with some distinctions.
Yes. Angelo's notes specify the president has no special absolute immunity from grand jury subpoenas. We saw that in Trump v. Vance in 2020.
The financial records case.
Right. The Supreme Court said a state grand jury could subpoena President Trump's financial records for a criminal investigation. Rejected absolute immunity from state criminal subpoenas. No citizen, not even the president, is totally above the duty to provide evidence.
Okay. But what about subpoenas from Congress? Is that different?
It is treated differently, yes.
Yeah.
For congressional subpoenas seeking presidential info, it requires a more nuanced balancing of competing interests. Congress has investigatory powers, sure, but courts will weigh Congress's need for the information against the burdens on the executive branch, the potential disruption of presidential duties. It's less of a clear path than a criminal grand jury subpoena.
Okay, that's a key distinction for the bar exam. Grand jury subpoena in a criminal context usually gets more weight. Now, let's switch to executive immunity. What does that protect the president from?
Executive immunity gives the president absolute immunity from civil lawsuits for money damages, but only for actions taken while carrying out the official duties of the presidency.
Official acts only. Which case established that?
Nixon v. Fitzgerald, 1982. The purpose is really practical. Protect the president from constant harassment by lawsuits that would distract them from their job.
So they can make tough decisions without fearing personal lawsuits over those official acts.
Exactly. Ensures they can govern without being constantly tied up in court over decisions made in their official capacity.
That sounds incredibly broad. Does it cover everything the president does? What about things before they took office?
Yeah. And this is a really critical distinction. You absolutely have to grasp this.
Yeah.
The absolute immunity does not extend to acts that happened before taking office.
Okay. Which case clarified that?
Clinton v. Jones, 1997. That case involved a sexual harassment lawsuit against Bill Clinton, related to conduct before he was president, when he was governor of Arkansas.
And the suit was allowed to proceed while he was president?
Yes. The Supreme Court said the immunity from Fitzgerald protects the exercise of official discretion while in office as president. It's not a blanket shield for private conduct that happened beforehand.
So immunity attaches to the office and its official functions, not the person for life.
Exactly. The court found a civil suit about pre-presidency conduct wouldn't significantly burden the office or interfere with official duties enough to warrant absolute immunity, ensures accountability for private conduct.
Okay, that's a crucial limitation. So wrapping this all up for the listener, understanding these nuances, Article 2, judicial review, domestic powers like appointments and removals, vetoes, external affairs, treaties, privilege, immunity, it's all essential for the bar.
Absolutely essential. It's not just memorizing rules and cases. It's about grasping the dynamics, the separation of powers, the checks and balances that shape our whole system.
Seeing the interplay.
Yeah. The executive branch, despite its vast powers, operates within this complex web of constitutional constraints. The interplay between the president, the courts, Congress, that's what ensures accountability. Being able to articulate those relationships, cite the key cases, explain the why behind the rules, that's critical for essays, for MCQs.
Okay. We've covered a ton today. The power of the executive branch, the overview, domestic powers, external affairs, privilege, and immunity. It's a huge chunk of common law.
It really is. And we absolutely couldn't have navigated it without Angela's invaluable constitutional law notes and outlines. They were the foundation for this whole discussion.
Seriously, so a huge thank you to Angela for sharing her work and letting us transform it like this.
And also big thanks to Carol for assisting Angela in getting all these materials organized for us today.
Definitely. Okay, now for some important housekeeping podcast issues we always need to cover.
Right. First off, super important to remember. Angela is a law student, just like you listening. She's not an expert, not yet anyway, and she hasn't passed the state bar yet.
Good point. Second, neither Angela nor this podcast, we're not giving legal advice. Okay, none of this should be taken as legal advice. And remember, AI, like us, isn't a substitute for actually studying for the bar exam.
Right. We're an aid, maybe a helpful supplement, but definitely not a shortcut to success.
Third, yeah, this podcast should supplement your learnings. It really shouldn't be the only way you're studying. It's one tool among many.
Fourth, AI isn't always perfect. Sometimes we make mistakes.
We do.
Angela tries very hard to fix any mistakes that pop up. And even Angela's excellent notes, well, even law students can make mistakes sometimes. We do our best to correct any wrong info we find.
Fifth, this podcast, the whole series, it's an academic, non-commercial venture by Angela, strictly for educational purposes. Angela makes zero money from this.
Right, so consequently, she makes no guarantees on its absolute accuracy. Use it wisely.
And finally, number 6, a safety reminder. When you're driving, please, the most important thing is be safe on the road.
Please.
So try not to cause a tort while listening to constitutional law.
Yes. Good advice. And remember, you can still contact Angela at podcast@studyforthebarinyourcar.com for general inquiries.
Or if you're an attorney needing help, it's hello@legalwriterandlawclerk.com for her freelance work.
Okay. And now, before we officially end, as tradition dictates,
it's time for the cheesy constitutional law joke. Okay, ready. Why did the First Amendment break up with the Fourth Amendment?
Why did the First Amendment break up with the Fourth Amendment?
Because it felt like it was always being searched without probable cause for a reasonable expectation of privacy.
Oh, okay. That's pretty good, actually. A little niche, but good.
This is Claude, your AI hosts, signing off.
We'll see you on the next podcast.
Thanks so much for listening. Bye.